You clicked accept, you signed the deal. Now what? Well, if you didn't read your fine print, you might have just handed over all the rights to your content, or locked yourself into some kind of an unfair deal, or lost your ability to work with other brands. Hey there, I'm Gordon Firemark, the podcast lawyer, and this is Legit Podcast Pro, the show that helps creators like you build strong businesses around your content without getting burned by the legal stuff. And today, we're diving into the real talk about contracts for creators. So let's kick it off with a story right after this. So here's that story I alluded to. It's a few years ago, a YouTuber I know, we'll call her Rachel. She landed a deal with a brand that seemed like a dream come true. Free gear, a monthly fee, plus bonuses if the videos performed well, and they did. She was thrilled. She signed quickly, didn't ask for legal help, but here's what happened. That contract included a clause that gave the brand exclusive rights to every video she made for them, including content on her own channel using their product. Now, she thought she was building her business, but she had unknowingly become their content creation department. When she tried to promote a different brand in a future video, that first company threatened legal action, and she had no idea what she had actually signed. So let's talk about what you need to know before you go signing any kind of a contract. First of all, what is a contract? Well, contract is the legal term for an agreement between parties that can be enforced in the courts or under the law. And contracts can be amazing protection, but it has to be the subject of mutual agreement. A contract is formed when two or more parties put their heads together and come to mutually agreeable terms, what we call mutual assent. And in order to be binding, a contract has to state a few things, including, what it's about, who the parties are, and what the consideration, the exchange of value is. So as I said, a contract can be a tremendous protection in your business, or it can be your biggest trap. So what should a basic creator contract include? Well, whether it's with a client or a brand or a co-creator or a service provider, here are some of the essential terms. First off is the clear identification of the parties. Who's involved? What are their names, emails, and business entities? And are they listed clearly? Secondly is the description of the services or the deliverables. What exactly is expected of all the parties? And then the payment terms. How much, when, are there penalties for late payments, those kinds of things. And then we have the ownership of intellectual property. Often this is one of the most significant and controversial points. Who owns the content that's being created? What about reusing it? Who gets to reuse it? In what ways? Is there a payment that happens when the reuse is made? Next up is the usage rights themselves. Are they getting non-exclusive use, or are you signing away full control, which is as good as signing away ownership in some ways? Finally, the duration and termination. How long does the deal last? And can either party get out of it, and how? You'll also want to include clauses about dispute resolution. If something goes wrong, how are you going to resolve things? You're going to use mediation, which is sort of a neutral third party coming in and helping the parties come to some understanding and mutually agreeable or sometimes disagreeable settlement. Or arbitration, where essentially an appointed judge or arbitrator decides for the parties. Or maybe you're going to just go to court. And where? What state or county? What country? If a contract is missing any of these elements, you should really take a moment and pause and ask for changes. Ask for clarification. All right, so let's talk about some red flags to watch for in contracts as creator. These are the kinds of things that should make your spidey sense tingle. First off, the phrase work made for hire. This means that the paying party will own the work, not the creator necessarily. Now, sometimes that's okay. That's how it would be, for example, if you were in a situation with an employee creating work for an employer, or if you've been hired and paid a cash fee that's enough to justify, okay, they own it. It's just work services, fee for service. And that's fine. But as long as you understand when it applies and what it means. Next up is perpetual and exclusive rights. If you're granting exclusive rights to somebody forever, you might as well be giving them ownership. So be very sure that the deal is worth it. A phrase that says something like, we can change this at any time, don't do it. That is not how contracts should work. Things need to be firm enough that an outside observer, a third party, a judge or a jury, could look at it and tell what the contract is about, and not that it's going to keep changing over time. It is possible and feasible to amend a contract, but that should be a subject of a separate written agreement after a negotiation. Another red flag is an unclear definition or description of the revenue share or how commissions will be earned. If there's money involved, the numbers should be spelled out. It shouldn't be vague. It should be very clear and easy to determine what the money's going to look like. And that includes if you're doing something that has a net profit calculation or a, after expenses, then there needs to be transparency about all those expenses, and they need to be clearly articulated in the document. There should be another red flag is that there's no mention of credit or attribution. You deserve credit on your work as a creator, and if it's not mentioned in the contract, ask for it. Specify how you want the credit to be given. Even though you're the one making the content, you don't want them repurposing it and lifting your credit off or stripping that off, right? So now maybe you're thinking, okay, Gordon, but I don't want to scare off a deal by asking too many questions. I get that, and I hear it all the time, but here's the thing. In business, professionals do negotiate. It isn't just take it or leave it in most instances. And if it is, that should also be a red flag. Asking questions doesn't make you difficult. It makes you smart. It projects the image of someone who is serious about what they're doing, takes it seriously, and treats things professionally. Negotiation is part of the game. So here are a few things that negotiation tips just for creators like you. First off, take your time. Don't sign on the spot. You can always say, let me review this and get back to you, or let me run this by my legal team and get back to you. Anybody who balks or pressures you to sign right away, that's a big red flag. Don't get into that trap. Ask your questions. Ask things like, can you clarify what this particular sentence is meant to mean? And it's always fair to ask them to clarify it in the document itself, not just an explanation over a phone call or something like that. Also, you need to know your bottom line. What are your sort of uncrossable lines? What are you not willing to give up as part of the deal? And if there are going to be changes in the contract, make sure they make their way into the contract writing. Do not rely on oral or verbal promises. Keep your tone collaborative, of course. Most brands and partners will respect a creator who protects their work. And try to do this all in as few passes as possible. So ask your questions, get them all out there, and ask for a redlined revised draft so you can look over the changes and make sure that makes sense to you. Now, when should you bring in a lawyer? Well, I'd say if it's a contract that's longer than a page or two, or if the rights language is complicated or complex, any of the language really, or if you're being asked to sign away ownership of things, excuse me, if there is real money on the table, or you just don't feel confident reading and understanding the wording of the contract, get some help. Even just a short consultation can save you thousands of dollars or your entire brand and livelihood. Now, quick side note. I go deep into how to read, understand, and negotiate creator contracts inside my Easy Legal for Podcasters program. And yes, there's even a whole sample video lesson that you could preview for free if you go on over to gordonfiremark.com/level-up. Now let's wrap this up with a few key takeaways. Top advice here is don't sign something unless you fully understand it. Don't rush or be allowed to be pressured into signing something until you're sure it's the right thing. Don't be afraid to say no to a bad deal. That little 2-letter word is the strongest bargaining chip you will ever have. The word no means, nope, no deal. And that is, it's a full sentence. Just use it and say, okay, I can't do it, right? Don't let fear stop you from standing up for your work and what's right. Contracts aren't just legal paperwork. They are the blueprint for how your creative business operates. And as your audience grows, as your content builds value, as opportunities knock, those contracts become more important than ever. So you should take them seriously. And if you need contracts you can trust, whether it's a sponsorship deal, guest release, co-host agreement, or brand partnership, come on over to easylegaltemplates.com or podcastlawforms.com, where you'll find contract form templates that you can use and rely on. You'll find professionally drafted templates designed specifically for podcasters, creators, and digital entrepreneurs like you. So until next time, keep on creating, keep on growing, and keep it legit. I'm Gordon Firemark, the podcast lawyer. Thank you for listening to this episode of Legit Podcast Pro. I'll see you again next week with another installment in our series. Have a great day.